and welcome back to the channel. Today I want to continue our document series in the case of Stephan Michael Stearns. The state of Florida has sent out their responses to the motions to suppress evidence that were obtained by the Google search warrant, the cell search, and the cell contents. And the first one that we're going to go over today is going to be state's response to defendant's motion to suppress evidence obtained from the Google search warrant. The purpose of this filing is that the state is opposing the defense's motion to suppress evidence that was obtained from a Google search warrant. They're saying that the warrant was supported by sufficient probable cause. It was not too overbroad. The law enforcement acted in good faith, and the exclusionary rule that they're citing does not apply here. The defendant was arrested pursuant to an arrest warrant in the above-styled case on February 29th of 2024. This is the procedural background or the history of the case. The state filed an information charging the defendant with the 60 counts that we have come to know for the CSAM material. This is 8 counts of sexual battery on a child under the age of 12. There were 5 counts of sexual battery with a child 12 to 18, familial or custodial authority. There were 7 counts of lewd or lascivious molestation and 40 counts of unlawful possession of materials depicting sexual performance by a child, with 10 or more images for each charge. The state provided discovery to the defense on March 20th of 2024, and the discovery has been ongoing. On February 6, 2025, the defense filed defendant's motion to suppress evidence obtained from the Google search warrant. The motion alleges there was violation to Stephan Stearns' Fourth Amendment right. The state's key arguments are as follows. On February 26, 2024, 13-year-old Madeline Soto was reported missing to the sheriff's office by her family. The family contacted law enforcement at approximately 4:30 p.m. There were 3 calls made to the Orange County Sheriff's Office prior to deputies' arrival. At approximately 7:35 p.m., Deputy Frankie Joseph with the Orange County Sheriff's Office made contact with Jennifer Soto, the defendant, and members of Miss Soto's family. All individuals were present in the lobby of the business building in which Miss Jennifer Soto's mother worked. Deputy Joseph inquired as to the identifying information for Madeline from Miss Soto and the family. The defendant stated he had dropped Madeline off at school that morning. The defendant described her as wearing a green hoodie, white Crocs, and either blue or black pants. Deputy Joseph also was informed that she had taken her cell phone to school that day. I think it should say Deputy Joseph also was informed that she had not taken her cell phone to school that day and only had her school computer. At approximately 7:47 p.m., Jennifer Soto provided Madeline's phone to law enforcement to review. Sworn statements were collected from the defendant and Jen Soto on February 26. The defendant's sworn written statement is as follows. Dropped off about a block or so from school, sometime between 8:25 and 8:40 a.m., turned around and headed back towards town. I watched in my rearview mirror as she made her way in the direction of school. She was busy searching through her backpack for something, but seemed to still be moving towards the school, so I carried on with my day. I stopped by a nearby vape shop, but it was closed, so I went home, and I left about an hour or so later to check the shop again. It was open, so I bought my vape juice and returned home, relaxed with Jen for a while. Later went out in the afternoon for a few more errands and returned home around 2:30. Jen Soto's written statement was as follows. Today, around 8 a.m., I saw her getting ready for school. I'm not sure what time they departed. Stephan Stearns took her to school and dropped her off close to school on Town Loop Boulevard, between Town Center Boulevard and Hunters Park Lane. Around 8:30 to 8:45 a.m., she never made it to school. I went to school around 4 p.m. to pick her up, and she never came out. I searched the area, went to my mother's office to look for Madeline, and could not find her. At approximately 9:05 p.m., accompanied by law enforcement, the defendant drove his vehicle to the area he claimed to have dropped her off at. The defendant stopped in the middle of the roadway and got out of his vehicle. The defendant claimed they were standing in the area in which he had last seen Madeline. Law enforcement provided the defendant with someone's cell phone. Deputy Joseph made contact with a church in that area and went through the video surveillance. At approximately 12:30 a.m., Officer Tristan Clark arrived at the home of Jennifer Soto and is greeted by Miss Soto and the defendant. Law enforcement was actively searching for Madeline. Looks like the word successful here. By all counts, the defendant was the last person to have seen Madeline. On February 27, 2024, at approximately 12 p.m., Detective Francis Hunt with the Orange County Sheriff's Office conducted an audio-recorded interview with the defendant. Detective Hunt swore the defendant in prior to asking him questions. The defendant reiterated that the last time that he saw Madeline was when he dropped her off for school the day prior. During this interview, the defendant told Detective Hunt that he did not recall the exact time of the drop-off because he left his phone at home. It was also during this interview that the defendant stated that Madeline slept alone with him in the upstairs bedroom so Jen could get better sleep. The defendant also told Detective Hunt that Madeline left her phone at the residence as well when they left for school. At approximately 7:16 p.m., an audio-recorded interview with the defendant is conducted by Detectives Mayra Tagler and Luis Acosta. The interview occurred at 4012 Santa Maria Drive, which is the Soto residence. The defendant was not in handcuffs and was free to leave. There were two plainclothes detectives conducting the interview of the defendant. The defendant stated that he and Madeline woke up between 7:30 a.m. and 7:45 a.m. The defendant again reiterated that he dropped her off. The defendant detailed their route on the way to drop her off. The defendant indicated that he tried to go to the McDonald's near Hunters Creek Middle School. However, he did not stop at McDonald's. The defendant estimated that he dropped her off approximately at 8:20 a.m. to 8:40 a.m. At approximately 7:37 p.m., after the defendant detailed all of this information, the following exchange occurred between Detective Tagler and the defendant. Do you mind if I look at your maps real quick? Yeah, that's fine. Thanks. The defendant unlocked his cell phone and handed it to Detective Tagler. There is some more clarification with Detective Acosta on the route the defendant took to the school and the location of where he claimed to have dropped Madeline off. Detective Tagler had the following conversation with the defendant. Do you mind if I just take a picture of your history? Yes, that's fine. The defendant and Detective Acosta discussed what time classes began at Hunters Creek. Detective Tagler had the following conversation with the defendant. What kind of phone is this? S23 Ultra, I think. I don't know how to work this thing. I'm sorry, I barely know how to work it myself. I'm an iPhone person. Oh, is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google. I am not logged onto my Google with that actually. Is it okay if I check? Yeah. There was some further discussion between Detective Acosta and the defendant. Detective Tagler then had the following conversation with the defendant. Hold on. I don't know how to use this phone. Sorry, I didn't mean to interrupt. Brief conversation occurred about Madeline's behavior. Is that what you use to go places? Yes. Go places, search addresses, look at store hours, write reviews. It is a pretty new phone, though. When did you come back to help Jen? Is that her name? What do you mean? Because you live down south. When did you come back up north to help her? I just got here this weekend. Do you remember what day it was? Sunday. Sunday was her birthday party. So yeah, it was the evening after her birthday party. Sunday. Okay. Do you remember what time you got here on Sunday? 8:30ish maybe? Okay. Just in time to make sure that she was doing all her nighttime routines, waiting for her mom to get home. You live in Northport, right? Yeah, I split my time between the two places. Is that on Snug Street? Yeah, that makes sense. You have a lot of Snug Street on here. Yeah, I split my time between the two. Detective Acosta inquired as to whether the defendant and Jen Soto went anywhere to look for Madeline February 26th of 2024. The defendant denied knowing whether they went to look for her because he had taken Ativan the night before because he had been so worried. Detective Acosta then went through the details of the directions for the route that the defendant claimed to have driven to take Madeline. Defendant went through the discussion again, but this time included timeframes. Detective Acosta then indicated that the defendant's vehicle was not where he indicated that he was, according to the traffic cameras in the area. The defendant then indicated that he went back home because he had forgotten his gate clicker. At 7:53 p.m., Detective Tagler handed the defendant his phone back. Immediately after handing the defendant his phone back, Detective Tagler stepped away from the defendant. Detective Acosta stayed with the defendant and they continued speaking. Detective Acosta and the defendant had the following exchange at approximately 7:54 p.m. Detective Acosta: how long have you and her mom been together? 6 years. I've known Madeline since she was 6 years old, so I have been helping raise her for half her life. She considered me like a dad, and I loved her like she was my own. At 7:57 p.m., Detective Tagler returned and has the following interaction with the defendant. Can you unlock this one more time, please? Sure. I have a question. Yep. Sorry, are you guys done? The other detective mentioned that you did not have your phone yesterday? Correct. Tell me about that. I left my phone home in the morning, too. I was so busy riding her or out the door on time that I left my phone. She left her phone. We both left our phones. Did you have your phone when you went to the smoke shop? Not the first time I dropped her off. I was still without it. Uh, I got it. Got my phone and went back to the smoke shop. Okay. Later when I got home. Okay. I also noticed I was checking your call history. I noticed that you don't have anything before this morning. Is that usual on your phone? No, it's a new phone. Stupid. I went to do an update yesterday morning, and I don't know what the fuck, pardon me. I don't know what the heck I did, but somehow during the massive OS update, I managed to factory reset my phone and lose all of my contacts, all of my information. Uh, mhm. What time was that? Do you remember? Oh, sometime while I was hanging out with Jen. Jen might know. I looked at her and said, "What did I just do?" Okay. She might know better. I don't know what time it was. It was when I was here with Jen. Okay, I don't think I have any other questions. At approximately 7:59 p.m., Detective Tagler advised the defendant that law enforcement was going to hold on to the defendant's phone. The defendant was told that he would receive it back when we are done. It was at this point that the defendant's phone was seized by law enforcement pursuant to this investigation. After this interview concluded, the defendant re-entered Jen Soto's vehicle and remained in the parking lot of the apartment complex. On February 28, 2024, at approximately 12:16 a.m., detectives Tagler and Acosta conducted a second audio-recorded interview with the defendant. During the beginning portion of this interview, Detective Tagler advised that law enforcement had been going through Madeline's cell phone and noticed a lot of conversations between her and the defendant. Detective Tagler asked the defendant to advise as to what type of relationship he has with Madeline. The defendant then stated she thought of me as a dad, thinks of me as a dad. Less than a minute into the conversation, Detective Tagler had the following exchange with the defendant. Sorry, I don't mean to cut you off. Your phone, I told you that I was gonna, hold on to it and that what we would like to download your phone, right? Okay. Is that something that I have your consent to do, or do I need to get a search warrant for your phone? Um, it should be fine. You're okay with us going through your phone? Yeah. Okay, can I have the pin to your phone? Uh, 42586. 42586. Okay, perfect. Thank you so much. Uh-huh. The defendant's cell phone was taken to the Orange County Sheriff's Office by Detective Acosta and submitted to the Digital Forensics Unit. A cell phone extraction was completed and the content was reviewed by detectives pursuant to the defendant's consent. Images located on the defendant's phone depicted Madeline, the missing 13-year-old juvenile, at various ages, being sexually abused. On February 28, 2024, Orange County Sheriff's Office authored an affidavit for search warrant for information contained within the defendant's Google account. The affidavit identified the user's name, sustenant@gmail.com, for the date range of January 1st, 2020 to present. The criminal conduct identified in the affidavit was interference of child custody and possession of material depicting sexual performance by a child. Detective Heller provided in this search warrant affidavit the following relevant background information. Your affiant, Taylor Heller, 9075, is and has been since May 25, 2018, a duly sworn deputy officer for the Orange County Sheriff's Office. Your affiant has a bachelor's degree from the University of Central Florida. I have successfully attended the Florida Basic Law Enforcement Academy, completed the Orange County Sheriff's Office Basic Recruit Training, and completed the Orange County Sheriff's Office Field Training and Evaluation Program. I am currently assigned to the Sex Crimes Unit and have investigated numerous adult and juvenile sex crimes cases, completed child sex crime training. I have investigated numerous internet crimes against children cases, training, and continuously complete advanced training in the area. Your affiant has authored arrest warrants and made arrests for the previous mentioned. The probable cause portion of the affidavit for search warrant identifies that Madeline was 13 years old when she was reported missing by her mother in 2024. The affidavit identifies the defendant, Stephan Stearns, as being the last individual that saw Madeline before her disappearance. The affidavit further continues that during an interview of the defendant provided consent to search his phone. However, he stated he had accidentally performed a factory reset on his phone on February 26 of 2024, the same day Madeline went missing. The affidavit indicates that during the investigation, it was discovered Stephan Stearns had several files of child sex abuse material involving Madeline on his cell phone, and the images were stored and backed up to his Google account, sustenant@gmail.com. Detective Heller also discusses his experience with Google. Detective Heller further details in his affidavit for search warrant the Google Cloud storage devices, specifically stating account holder users can utilize this service called Google Drive to store pictures, videos, and other electronic files remotely and without taking up memory space on their personal computer, smartphone, and physical storage media. After reviewing the affidavit for search warrant submitted by Detective Heller, the Honorable Circuit Judge Reginald K. Whitehead determined that there was a probable cause to issue a search warrant for the defendant's Google account. The search warrant was issued on February 28 of 2024. On March 1st, 2024, detectives from the Orange County Sheriff's Office downloaded and reviewed the Google search warrant return. Several images and videos in the search warrant returned were depicting the sexual abuse of Madeline. Several images and videos in the search warrant return were depicting the sexual abuse of Madeline. Those files were present in the defendant's Google account data during the date range provided in search warrant affidavit. The defendant's motion cited to Florida Rule of Criminal Procedure and as grounds for suppression of the Google search warrant return evidence. Pursuant to Florida Rule of Criminal Procedure, if the court hears the motion on its merits, the defendant shall present evidence supporting the defendant's position and the state may offer rebuttal evidence. When evidence has been obtained by law enforcement pursuant to a warrant that was served, the burden is on the defendant to establish grounds for suppression. The allegations set forth in the defendant's motion are not evidence, and the defendant shall present evidence supporting his position at a hearing. Law enforcement obtained a search warrant prior to searching through the defendant's Google account information. As such, the defendant is challenging the search warrant issued for this information. The trial court's role in reviewing the decision of the Honorable Circuit Judge Whitehead is to ensure that there was a substantial basis for concluding that probable cause existed. Probable cause is established when two elements are set forth in the affidavit for search warrant. One, the commission element, a particular individual has committed a criminal offense, and two, the nexus element, evidence that is relevant to the probable criminality is likely located at the place requested to be searched. Courts reviewing the probable cause determination of another judge or magistrate should afford great deference to that decision. A grudging or negative attitude by reviewing courts towards warrants is inconsistent with the Fourth Amendment's strong preference for searches conducted pursuant to a warrant. Courts should not invalidate warrants by interpreting affidavits in a hyper-technical rather than a common-sense manner. The trial court should not disturb any issuing magistrate's determination absent a clear demonstration that the magistrate abused his discretion in relying on the information in the affidavit supporting the warrant application to find probable cause. Probable cause developed during consensual search. The legality of the searches and seizure of the defendant's cell phone is discussed in state's response to defendant's motion to suppress evidence obtained for unlawful seizure of cell phone, and state's response to defendant's motion to suppress evidence obtained from unlawful searches of cell phone. As such, the state's position is that the evidence obtained from the defendant's cell phone was legally obtained by law enforcement. Law enforcement relied on information obtained during the consensual search of the defendant's cell phone to support the probable cause recited in the affidavit for search warrant related to the defendant's Google information. Therefore, the exclusionary rule as fruit of the poisonous tree is inapplicable to the Google information obtained pursuant to the search warrant. When reviewing an affidavit for search warrant, the probable cause determination must be made by examining the four corners of the affidavit. Conclusory statements or bare conclusions are insufficient to support a finding of probable cause by a judge reviewing an affidavit for search warrant. In Gosel v. State, the issuance of a search warrant was challenged by the defendant, claiming that the affidavit was insufficient to support probable cause. The affidavit indicated that a photo was reviewed by the affiant. The affiant determined that the photo did in fact depict child nudity. The affidavit lacked any information to independently determine whether the photo constituted child nudity as opposed to lawful non-obscene nudity. The affidavit also failed to demonstrate any training or expertise in identifying child nudity that the affiant had. The affidavit stated he was in the intelligence section and conducted digital forensic examinations. The affidavit further detailed that he had history of involvement in child nudity investigations, was a member of the Central Florida's Internet Crimes Against Children Task Force, and conducted investigations related to possession and transmission of child nudity. The court found that all of the training listed was technology-related training. The court found that the affidavit was insufficient to support probable cause to issue a warrant. In State v. McNeela, the court addressed arguments that a search warrant affidavit was insufficient to support a probable cause finding related to allegations of possession of child nudity. Detectives received a NCMEC cyber tipline report regarding 4 images uploaded by a specific IP address. The detectives confirmed that the IP address was registered to McNeela. Law enforcement conducted an interview at which time McNeela provided consent to search his computer, of which he was the primary user. An external hard drive plugged into the computer was also searched as part of the consensual search, at which point law enforcement seized the computer and hard drive and sought search warrants. In the affidavit for search warrant, the images sent in the original tip were described in graphic detail. Law enforcement classified the images observed during the consensual search as child nudity. None of the images observed by law enforcement during the consensual search were described, nor were any identified as being an image related to the original tip. The court found that the warrant affidavit contained sufficient probable cause. In State versus Wooldridge, the court again addressed allegations that a search warrant affidavit was insufficient to support a probable cause finding relating to allegations of possession of child nudity. Detectives received a NCMEC tip regarding a specific AOL user attempting to email files containing child nudity. The affidavit for search warrant detailed the investigation relating to Wooldridge being linked to the subscriber information for the screen name. The detective indicated that they viewed the images related to the tip and also detailed his background in the investigation of online child nudity cases. The Wooldridge opinion gives no indication that the affidavit there described the image themselves. Instead, the affidavit relied on the officer's training and experience to establish their nature as contraband. The Wooldridge court reversed the trial court's order granting the suppression of evidence seized pursuant to the search warrant, finding that the conclusion the affidavit did not establish probable cause was incorrect. In State v. Peltier, the court again addressed the sufficiency of an affidavit for search warrant relating to an investigation into the crime of possession of child nudity. The affidavit for search warrant detailed files that were uploaded from the defendant's computer with hash values previously identified as child nudity. The affidavit identified videos and images of child nudity and the child erotica on Peltier's computer shared through peer-to-peer networks. Images and videos obtained from Peltier's computer, as detailed in the affidavit, contained files depicting the female child victim exposing her genitals in a lewd manner or engaging in various sexual activities with an adult male. Finally, the affidavit indicated other uploaded files were of child nudity, depicting a minor female child engaged in sexual conduct and sexual battery. The court stated, "Our records reflect that the various media contained in Mr. Peltier's computer and offered through BitTorrent to the public included images of the female child victim exposing her genitals in a lewd manner, engaging in various sexual activities with an adult male, and a minor female child engaging in sexual conduct and sexual battery. These descriptions cannot be confused with innocent content." In the case at hand, there is a substantial basis for concluding that probable cause existed to support the issuance of a search warrant for Stern's Google account. As was the case in Peltier, the description given by Detective Heller in the affidavit for search warrant cannot be confused with innocent content. Detective Heller specifically identified Madeline, 13 years old at the time the affidavit was drafted, as being depicted in several files of child sexual abuse material. An affidavit for search warrant detailing probable cause must provide information supporting the probability of the evidence of the crime will likely be located in the place to be searched. To satisfy the nexus element, the affidavit must establish the particular time when the illegal activity that is the subject of the warrant was observed. A magistrate is not required to leave common sense at the courthouse door when evaluating whether a supporting affidavit satisfies the nexus element and supports a finding of probable cause. In the affidavit for search warrant, Detective Heller indicated that the current investigation began on February 26, 2024, with Madeline Soto being reported as missing. Detective Heller indicated that interviews were conducted, mentioning an interview specifically of the defendant. The affidavit details the statements the defendant made about dropping Madeline off on February 26, 2024. The affidavit also reflects that the defendant consented to a search of his phone and also stated he performed a factory reset on his phone on February 26, 2024. During a search of the defendant's cell phone, several files of child sexual abuse material involving Madeline were located. It was also stated that the defendant's images were stored and backed up on his Google account, sustenance@gmail.com. Further, Detective Heller discussed the Google Drive and the storing of photographs from smartphones. Finally, the affidavit for search warrant was authored by Detective Heller on February 28, 2024. The affidavit for search warrant for the defendant's Google account provided a sufficient basis for the Honorable Court Judge Whitehead to determine that evidence related to possession of child nudity would likely be located on the defendant's Google account. The affidavit mentions that the defendant's factory reset the cell phone on February 26, 2024. The defendant then provided the consent to search his cell phone, files of child sexual abuse material involving Madeline on his cell phone, and the images were backed up on a Google account, specifically sustanet@gmail.com. Also, the affidavit for search warrant supported a probable cause finding that evidence related to interference of child custody was contained within the defendant's Google account. Detective Heller detailed that 13-year-old Madeline was reported by her mother on February 26, 2024. An extensive search and interviews were conducted. The defendant stated that he dropped her off in front of Peace United Methodist at approximately 8:40 a.m., even though classes did not begin at the school until 9:30 a.m. A license plate reader captured the defendant's vehicle tag traveling away from the school. The defendant backed up images from his cell phone to his Google account. It is probable that other information on the defendant's cell phone prior to the factory reset was backed up as well. Google maintains GPS data and other data, which was described in the affidavit for search warrant. The defendant's movements and activity that may have been backed up onto his Google account supports a nexus that evidence related to the interference of child custody would be located. The implementation of standard language grafted into a search warrant related to the operations of Google is helpful and relevant in the affidavit for search warrant. Law enforcement does not need to reinvent the wheel for every application, and this background information is accompanied by the case-specific information. The observation that images of child nudity are likely to be hoarded by persons interested in those materials in the privacy of their homes is supported by common sense and the cases. Since the materials are illegal to distribute and possess, initial collection is difficult. Having succeeded in obtaining images, collectors are unlikely to quickly destroy them. Because of their illegality, collectors will want to secret them in secure places, like a private residence. This proposition is not novel in either state or federal court. Child nudity collectors maintain their materials for significant periods of time. In this case, there was evidence to support that the defendant was an individual that fell into this category by the information that the child in the sexual abuse material was the defendant's stepdaughter, and the material was located on his cell phone and back up onto his Google account. The Fourth Amendment requires that warrants particularly describe the place to be searched and the person or thing to be seized pursuant to it. The particularity requirement prevents the seizure of one thing under a warrant describing another. If there is indeed probable cause to believe the fruits or instrumentalities of crime are to be found in a particular place, the warrant applicant should be able to explain to the magistrate with some specificity what those items are. In Lamb, the defendant challenged the warrant as lacking particularity when it sought all stored files in original format in individual files. The court determined that although the language does not limit investigators to seizing image files only or image files of child nudity only, the actual content of a computer file usually cannot be determined until it is opened with the appropriate application software on a computer. Any overbreadth in the warrant did not taint the remaining portions that were not overbroad. American jurisdictions are in general agreement that partial invalidity of a warrant does not in itself render the remainder invalid. In the case before the court, the application for search warrant for the defendant's Google account information was not overly broad. The affidavit for search warrant elicited specifically what was being sought by law enforcement in relation to the warrant and investigation. When a law enforcement officer acting with objective good faith obtains a search warrant and acts in accordance with the warrant and its scope, Suppression of the evidence obtained is not appropriate if a reviewing court later determines there was not probable cause. Exclusion is appropriate in cases in which the issuing judge was misled by information the affiant knew to be false or would have known to be false but for the reckless disregard of the truth. Exclusion is also appropriate in cases in which the affidavit is so lacking in probable cause that any reliance on it would be unreasonable. Even if the court determines that the affidavit for search warrant of the defendant's Google account was insufficient to support a finding of probable cause, law enforcement acted in good faith, reliance on the warrant that was issued. Law enforcement did not provide any information in the warrant that was false or misleading in the affidavit for search warrant. Also, the search warrant was not so lacking as to make any reliance on the warrant unreasonable. In conclusion, law enforcement drafted an affidavit for search warrant for the defendant's Google account information that sufficiently set forth probable cause for the search. Therefore, the defendant's motion seeking to suppress the evidence obtained from the Google search warrant should be denied.